Well, hello and welcome to my Fireside Chat video where I am providing consultation to state legislators, national legislators as well, but more focused with the state legislators regarding the pathology and the problem that we have in the family courts. And there's a significant problem. If you're watching this, it's likely that one of your constituents asked you to watch this. And I have another video or set of series where I was asked to present to the um, Pennsylvania legislature, and that's up on YouTube as well, but that's longer than this. And so in this particular video, I'm going to be just providing some consultation to state legislators regarding the issues and the needs of their families and their constituents over here. My background, I'm a clinical psychologist in the family courts, and I'm currently involved as an expert second opinion on forensic custody evaluations and mental health services in the family courts. And we're trying to get competent mental health services for these families, and it's near impossible. They're in a difficult situation and can definitely use some legislative oversight of what's happening in the family courts to help move things into a solution for these parents and for their children. So the fundamental problem that we're having in the family courts is that we have abandoned families, man, abandoned children and parents. Professional psychology has abandoned the parents and children in the family courts. Forensic psychology, which is the child custody evaluations, represents a failed experiment in service delivery to a vulnerable population. They experimented on these families and it failed. And now their families and the court system is in a difficult situation because of that. The clinical psychologists, the treatment providers, haven't worked in the family courts for 40 years. They've given it over to the forensic psychologists because they refuse to work in the family courts because it's too dangerous to their licenses to be over here. And then the pathology is also non-treatable because of the court's involvement. So the forensic psychologists don't work here in the family courts. They refuse. And the forensic psychologists are absolutely the worst imaginable. And so that's our problem sitting over here. And relative to the forensic psychologists, this is something that legislators need to kind of understand and take in, is that a whole field of psychology is extraordinarily problematic. We created this special group of psychologists for the family courts. That was a bad thing to do. It was a mistake and it's failed. And we got to return to court involved clinical psychology treatment, not custody. So here's what the findings from an independent review of forensic psychology and their custody evaluations. This is what they found. New York Blue Ribbon Commission on Forensic Custody Evaluations. Ultimately, the commission members agree that some New York judges order forensic evaluations too frequently and often place undue reliance upon them. Judges order forensic evaluations to provide relevant information regarding the best interests of children, and some go far beyond an assessment of whether either party has a mental health condition that has affected their parental behavior. In their analyses, evaluators may rely on principles and methodologies of dubious validity, and in some cases, because of a lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for the parents and children. By an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. Now, my role right now, what I do right now, is a consultant in the family courts. So I get to read these forensic custody evaluations. That's my job as a second opinion consultant to these mental health services. I am in the full agreement, 100% with the findings of the New York Blue Ribbon Commission, that these reports are defective. leading to potentially disastrous consequences. They lack scientific and legal value. They are dangerous potentially, and they should be eliminated from the courts. But that's going to create a lot of crisis in the court system. It is creating crisis in the court system where there's no competent mental health services available to these children, to the parents, or to the court. And so that's where we are needing some legislative guidance and intervention to put things back on the proper track with mental health services in the family courts and for the families and the children and the families to get these things fixed. The New York Blue Ribbon Commission concluded that these members reached the conclusion that the practice of forensic custody evaluations is beyond reform and that no amount of training for courts, forensic evaluators, and or other court personnel will fix the bias, inequity, and conflict of interest issues that exist within the system. So it's not just simply a matter of coming up with judicial curriculum or little tweaks on the system. And that's where I would encourage that the legislator kind of hold some hearings about what's happening in the family courts to kind of get more information about that, then some directions can be taken to improve things. The forensic psychology in the family courts is a failed experiment in service delivery to a vulnerable population. In its failure, the lives of thousands upon thousands of children and their parents were irrevocably destroyed. And it's going on right now. We're continuing to lose families on a daily basis, as your constituents are coming to you complaining about. So the first thing I would suggest is some legislative guidance. We need some guidance from the legislatures to the mental health professionals, to the doctors. That I think the guidance that can be provided by the state legislature is in updating mandated reporting laws to provide a definition of child psychological abuse, because that's what we're worried about in the family courts is psychological abuse of the child by a narcissistic, borderline, dark personality parent. And the dark personalities are extremely bad. Psychopathic, highly manipulative, borderline spectrum as well, narcissistic and potentially sadistic. So we got some very serious personality pathology in some of these parents, and they are manipulating the court system, and the pathology in the family courts is child abuse and spousal abuse, and particularly psychological abuse by this narcissistic borderline parent of the child. And so getting or mandated reporting laws are focused on physical and sexual and neglect abuse, but ignore the psychological abuse side. Don't deal with it. You might have emotional abuse, but it's not a clear definition of what that entails. And so nobody's diagnosing and nobody understands what's happening. But it's a persecutory belief system. It's a persecutory thought disorder, false factitious attachment pathology being created in the child. And so what would be helpful, there's 4 DSM-5 diagnoses of child abuse: physical, sexual, neglect, and psychological. And what would be helpful is for the state legislator to clarify that the definition of psychological child abuse to include something like creating significant pathology in the child, or creating significant attachment pathology in the child, put the attachment word in there, or a persecutory thought disorder, or thought disorder or attachment pathology. Anything that indicates that the legislature is aware of what the concern is will be a bullhorn communication to all mental health people in the family courts that it is the legislator's intent that we protect children from this particular type of child abuse, the narcissistic borderline parent creating significant pathology in the child. Simply by just tweaking a few words in that child mandated reporting abuse law to include a definition of psychological child abuse. And putting to include that as a permissible report. So it doesn't have to be a mandated report. Psychological child abuse shouldn't be a mandated report. It's too vague, but permissible report. So if a psychologist sees this going on, they should indicate it over to Child Protective Services. Now, also, that when, or in addition, in providing a definition of child psychological abuse in the mandated reporting laws would give a clear indication to all mental health professionals that it is the intent of the legislature to protect children in the family courts from psychological child abuse by their parents. I think additional guidance to the judges would also be helpful, and that has to do with the judicial curriculum. Now, there's movements on board right now to get a judicial curriculum for the judges in the family courts, and people are recognizing that that's valuable. It needs to be a balanced curriculum. There are 2 litigants and there are 2 allegations of child abuse, each one from each parent. So the allied parent and the child's symptoms are making an implied allegation of abusive parent toward parenting by the targeted parent, and potentially the allied parent is making overt allegations of abusive parenting by the targeted rejected parent. In addition, the targeted parent is alleging that the allied parent is psychologically abusing the child, creating this false attachment pathology, a persecutory thought disorder in the child for secondary gain to that parent. So both litigants, both parties, are alleging versions of child abuse against the other. So we need to get a proper diagnostic risk assessment towards that pathology. What the court benefits from is a balanced description and education about what each litigant is concerned about, and then what do you do about it? And what do you do about it is you get a diagnosis out of the psychology people. And so getting that education that's balanced to both concerns of both parties, and then what to expect and how to resolve that out of the mental health system, that sort of judicial curriculum guidance would be very helpful from the legislatures. So I would suggest university involvement should be sought to develop a balanced judicial curriculum for family court judges that educates on the concerns of both parents. Judges don't diagnose pathology, doctors do. So indicating through the judicial curriculum the central importance of an accurate mental health diagnosis will help establish the proper guidance for the courts. This is a pathology. It needs treatment and resolution. We need to stop fighting around these children. The third recommendation is a legislative solution. And so the other 2 were providing guidance. This is what I would recommend, as if a legislature wants to take on the solution for the family courts, this is my recommendation, a pilot program for the family courts. My estimate would be about a 2-year program. So the goal of the pilot program would be to develop a structured and agreed upon diagnostic assessment and treatment protocol for the family pathology in the family courts. The pilot program should be initiated with university involvement for evaluation research to develop a standardized diagnostic assessment and treatment protocols for the differential diagnoses of concern in the family courts. So we have a problem. Okay, we need a solution to the problem. My recommendation is to task the top universities with the solution, coming up with the solution. We've got some of the best people ever in these universities. They just simply need the marching orders, the task. And so the pathology, we have 2 different concerns, 2 different litigants. One's worried about physical child abuse or sexual child abuse. The other's worried about psychological child abuse, persecutory delusion. So we can, if we ask our universities to come up with a diagnostic assessment protocol for that, they can do that. And then you ask the law school associated with the university come up with the legal support arguments that underlie that path and how to do that. They can come up with a solution. And so that would be my recommendation. And then you get the evaluation research on it to make sure that we're effectively solving the problem in the family courts. So um, the high quality standardized diagnostic assessment and treatment protocols will provide the professional safety for the clinical psychologists to return to the family courts. So there's two problems pointed out to begin with. One is forensic psychology is a failed system, but the other is that the clinical psychologists, the treatment providers, won't work in the family courts because it's too dangerous to our license. And if you threaten the license of a doctor, the doctor's not going to work with you. They're in the family courts. And so you're going to get a very low quality of mental health services because you're threatening the license of the doctors who work here. And they shouldn't have to put their license on the line to work with pathology. And so the way to solve that is to come up with a standardized diagnostic assessment protocol and treatment protocols that if the clinical psychologists do this, then we'll be okay, we'll be safe. Then we're safe, and we will come back to work with the families because we care about child abuse, we care about spousal abuse. We'll be back if we don't have to put our license on the line. So help us out with that and get us a pilot program that produces the assessment and treatment protocols that we need on this situation. So with that, I'm going to wrap up my consultation to the state legislators. I have general public consultations first week of every month. If you want more information, it's available on my website as well. And thank you for checking me out and taking the time to orient the problem in the family courts. It's a serious problem over here that needs focused attention, as the Blue Ribbon Commission indicates. Once attention's focused over here, bad things pop up. So with that, take care. Bye.